and another versus the Secretary of the State for the Foreign and Commonwealth Affairs, part heard. Parties are reminded that recording of this hearing is not permitted. Thank you.
Yes, good morning, everybody. Ms. Kaufman was addressing us.
Yes, my Lord. Can I just clarify before we kick off properly whether or not today your Lordships are able to see me?
Yes, I can see you. Everybody else?
I can see you.
Yes, you're fully visible.
That's a better start than yesterday, I'm grateful. So yesterday we were dealing with the right of abode of common law and its continued relevance for the decision-making process. Just before we move on to the right to self-determination, can I take your Lordships to the part of the Divisional Court judgment that dealt with the issue of whether or not that right has any continued bearing? It's at paragraphs 103 and 104 of the judgment, which is in the core bundle at tab 21, and the relevant page is 212. So the Divisional Court dealt with the matter very, very briefly and straightforwardly. Paragraph 103, we do not consider that the present case concerns fundamental rights of common law. We agree with the submissions that have been made on behalf of the Secretary of State by Sir James Eadie in this regard. This is not a case where fundamental rights are affected, unlike Smith, because the court has to proceed on the basis that the legal rights which existed previously have been extinguished, at least by the 2004 orders. And that 2004 order is not something that is being or can be challenged in the present proceedings. So that was the position of the Divisional Court, and for the reasons I gave yesterday, we submit that that was wrong. And since that judgment, as Mr. Jaffe told the court yesterday, the ICJ gave its opinion in its advisory opinion, and that advisory opinion has given rise to a further right upon which the appellants place reliance in this appeal. And so the first question, that's the right to self-determination as a matter of customary international law. So the first question for your Lordships to consider, we submit very briefly, is whether or not we have permission to appeal based upon reliance on a right to self-determination as a matter of customary international law. That is something which your Lordships would have seen the respondent has submitted we do not have. So I'm going to briefly make good why it is that we do have permission. It's going to require your Lordships to look first of all at our application for permission to appeal and the skeleton argument that we put in support of that application. That's in the core bundle, the same bundle your Lordships had open to look at the Divisional Court judgment. It's at tab 33. Page 563 is the relevant page. And if your Lordships can just read paragraphs 14 through to 17. Relying upon the ICJ advisory opinion in support of our ground that the Divisional Court failed to apply anxious scrutiny. When that came to be considered by the Court of Appeal in granting permission to appeal, your Lordships will see from paragraph 6, the key paragraph, that it clearly covered the ICJ opinion. If your Lordships stay in the same bundle, turn back to tab 3. paragraphs 5 and 6 of page 9 of the bundle. So there at 5, the court is addressing our ground based upon a failure to review the decision with sufficient intensity of review. And there the court, despite recognising the attractiveness of parts of the judgment, nonetheless grants permission to appeal. And then at 6, again we make clear that although the paragraphs in question were the principal focus of the submissions before us, our permissions cover the other ways in which the ground is developed in the skeleton arguments, filed on behalf of Mrs. Hoareau and Mr. Banku. And that quite clearly covers the entirety of the way in which the Divisional Court's decision was challenged, including our reliance at paragraph 17 upon the ICJ opinion. So in our submission we do have permission to appeal. We have traversed this territory repeatedly with the respondent in correspondence. They continue to maintain their position, albeit your lordships would have seen that they have prepared a fulsome response to the submissions that we've made in reliance on the ICJ opinion. So can we turn to that opinion? That is in the Core Authorities bundle, and it's at tab 36. We can go with it pretty swiftly because Mr. Jaffe yesterday took us through most of the parts of which cover the territory that I want to take your lordships to now. But there are a couple of points I'd just like to focus on, because we're dealing now with the question of the status of the right to self-determination as being a right recognised as part of customary international law. So paragraphs 144 to 160, your lordships don't need to look at it, we see the ICJ tracing the relevant custom and opinion juris in relation to the right to self-determination. And then at paragraphs 152 to 3, the ICJ clarifies that this is a right which is a matter of customary international law. It is a right to self-determination in the peoples of non-governing territories.
Sorry, Ms. Campbell, can you just give me the page number?
I'm so sorry, that's page 1717.
Paragraph 152.
152 and 153.
153, thank you.
Your lordships, just look at those two paragraphs and then move on to paragraphs 159 to 160. To 160. And could your lordships read those? In particular, all of paragraph 160. So the first part, we see a recognition of the customary status of the right, and then 5 lines from the bottom, the court considers that the peoples of non-self-governing territories are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. And what that went to was the detachment of the Chagos Archipelago when Mauritius was granted independence. independence and the failure, therefore, properly to respect the right to self-determination. And then at 174, we've seen that the court finds that the process of decolonisation was therefore not lawfully completed. And Mr. Jaffe yesterday took you through to the court's advice in relation to the consequences of that and the continuing administration of the archipelago. And if I could ask your lordships to look again at 181, because this is where there is a recognition that the issue of resettlement is one which relates to the protection of the human rights of those concerned. That is obviously the peoples of Mauritius, including in particular the Chagosians who had been residing there at the time that BIOC was created. And that is the question of resettlement, the ongoing consequences of the original illegality concerns their human rights, because resettlement is obviously an essential precondition for the full realisation of the right to self-determination.
Can I just ask, Miss Carlton,
Yes.
that is specifically limited, as one might expect, to the resettlement of Mauritian nationals on the Chagos archipelago, including those of Chagosian origin. It says nothing about those Chagosians in the Seychelles, of course, because this was dealing with the decolonisation in relation to Mauritius. So what significance does that have as to the difference between those Chagosians who
Well,
are...
this comes down to what we take from this judgment. What's the relevance of this judgment? It is not that this judgment is binding upon this court in any sense. What this judgment is an authoritative statement upon the status of customary international law and how that applies in relation to the decolonisation of Mauritius. So this court is entitled to look at this and to conclude from this that firstly, the right to self-determination is a right recognised as a matter of customary international law. Secondly, the court is then entitled to ask itself, well, if that is so, given what is known about the process of decolonisation, what are the implications for the rights to self-determination of the individuals who were, at the time that BIOC was created, enjoying their right of abode in the Chagos Islands? Now, that will include those who later found their way into Mauritius and those who found their way to the Seychelles. And this court is perfectly entitled, taking the statement or the authoritative nature of the advisory opinion as to the status of customary international law, and is able for itself to recognise what we submit necessarily follows, given the undisputed factual situation, that the right of self-determination of all Chagosians, whether they found themselves in Mauritius or they found themselves in the Seychelles, is one that was violated by the creation of BIOC and is one that continues to resound and affect them.
So can I just put, so as I understand it, you're saying that we can and should take from this judgment not simply the issue of self-determination in the context of decolonisation, but rather a more general point about the right of everybody to self-determination, irrespective of the particular issue here, which is the decolonisation of Mauritius.
Absolutely. So what this judgment recognises as a matter of fundamental law and principle is that the right to self-determination is a right enjoyed by peoples as a matter of customary international law. That is the key point of principle that is established in this judgment. It is established in the context of the decolonisation of Mauritius. And that's obviously highly relevant and persuasive. But one is not limited to what the court was focusing on here, that is the dispute between the Mauritius and the United Kingdom. What one extracts from it are what are the implications of that? What are the implications of the fact that, as a matter of customary international law, peoples enjoy a right to self-determination over the territories where they abide, where they live, which is their home. And that applies as much to the Seychelles Chagosians as it does to the Mauritian Chagosians. They are all victims of a violation of that right with ongoing consequences and with an interest, a profound interest in their resettlement in order to re-exercise that right to self-determination.
Ms. Kaufman, can I just ask one question on the ICJ opinion? I understand what you say about having permission to appeal on it. I also understand what you say in relation to how it feeds into some of the arguments about the human rights engaged. But just in public law terms, which is part of your challenge, obviously this opinion didn't exist at the time the government made its decision. And no doubt you would say the government will have to react to it. So how does our analysis of this opinion engage the public law issues in this particular case?
So the fact that the ICJ hadn't given its opinion at the time we submit is irrelevant, in that what the ICJ is here doing is giving its advice on what the status of customary international law was at various points in time, starting with the moment of independence and coming right through to today. And what the ICJ concludes is that as a matter of customary international law, back in the late 60s, 1965, when BIOT was created, the right to self-determination already existed. And therefore, whether or not the ICJ gave its opinion after the decision was taken, that right was already in existence and felt to be taken into account, and is a reason why anxious scrutiny needs to be given to the decision-making process. And so we submit it doesn't have a bearing.
Can I just ask this question? So it's a rather naive question, I suppose, in a way. But if the principle to be derived from this is as wide as you say, in other words, taken out of the Mauritian context, does that mean that in the case of every identifiable group of people who have not been given separate status of their own, that the country which, as it were, is exercising control is acting unlawfully in every country in the world?
In colonised countries, those countries have a right to self-determination. So unless they are a country where they themselves have determined that they continue to have governmental relations between their state and a colonising state, as it were, then yes, they are not free to exercise their right to self-determination, and that status of being a colony is an unlawful status.
So it's specifically, so the context for this is the context of a colony. I thought you were extracting a much wider principle.
No, I'm so sorry. No, this ICJ judgment deals only with the situation of colonisation. They make that clear early on in the judgment that is what they are looking at.
The principle that I took down from you was the right to was that what was being advised upon here was the right to that the right to self-determination is enjoyed by all people as a matter of customary law. That was the broad principle I think you specified.
I'm very sorry. Let me take you back to 144, I think it is, where they make clear that they are only dealing. At 144, page 1716, the court is conscious that the right to self-determination as a fundamental right has a broad scope of application. However, to answer the question put to it by the General Assembly, the court will confine itself in this advisory opinion to analysing the right to self-determination in the context of colonisation. So that is specifically what it is looking at. That's specifically and solely the basis upon which I am making submissions in respect of this judgment and its authoritative status. But it does mean that for the Seychelles Chagosians, who lost their right to self-determination in the context of decolonisation, this advisory opinion and the principles which it enunciates apply equally to them as they do to the Mauritian Chagosians.
Thank you.
Can I don't want to be the only person who doesn't ask you a question. If you're right, who is bound to respect the right of self-determination? You equate self-determination with the right of abode, but the logical implication of the judgment is that it is the state of Mauritius who would have responsibility for resettling the Chagosians from wherever they come, not the United Kingdom. So how does that impact upon the rights or the remedies that you seek against the defendant in these proceedings?
So the way it impacts is that is right. Mauritius will resettle them. Mauritius can only resettle them, needless to say, if the territory is ceded by the United Kingdom to Mauritius. And until that happens, their rights continue to bear upon any decision that the respondents make in relation to the archipelago, because those decisions have a bearing upon the extent to which any of those rights might be realised before Mauritius itself can perform its own obligations.
If an English court grants some form of appropriate remedy, conferring upon the Chagosians a right of resettlement, wouldn't that be inconsistent with the resolution of the General Assembly, which requires us simply to assist Mauritius in resettling? And it assumes that Mauritius is the power that has responsibility for resettling, not the United Kingdom. After all, the basis of this opinion is that we don't and never had the lawful power to do that.
Well, it certainly wouldn't give effect to the opinion. There's no question about that. Effect to the opinion, effect can only be given by the United Kingdom to those rights by ceding the territory. But as long as it doesn't cede the territory, it has to consider how those rights continue to bear upon it. And if it just chooses not to comply with the full scope of its obligations by ceding, it can nonetheless take action which either to a greater or lesser extent is consistent with the exercise of the rights. So, allowing individuals to resettle.
In this interim period, under the UN resolution, the United Kingdom has a duty to, as it were, cease and desist, withdraw the administration within 6 months, and do everything possible to cede control to Mauritius. I mean, I thought the implication of the opinion, if you're right, is that it's not for the United Kingdom to guarantee the remedy, that you seek it for Mauritius.
I totally accept your premise that the United Kingdom can only guarantee the remedy by ceding the territory. That is, it can guarantee the remedy in that sense, of course. It can remove itself from the territory. And that then opens up the possibility for Mauritius to take steps to resettle. But so long as it doesn't do that, it has to continue to take account of that right. And it has to ask itself the question whether or not the actions that it takes are more or less respecting of that right in practice. So recognising that unless it gets out of the territory completely, it is not going to be complying with that judgment, it nonetheless is able to do things that are more or less consistent with the enjoyment of that right. So allowing people to return and settle while they still remain in violation of the overarching right to self-determination is nonetheless a less extensive violation of the right. Individuals are able to enjoy aspects of the right if they can be present in, living in and settling in the Chagos Islands.
Is that consistent with the General Assembly's order and demands that we should essentially do nothing which disturbs the status quo but simply withdraw? And I understand your point, and I see the clever stick. If the UK accepts the opinion, then it acts accordingly and everything unravels. If it doesn't, then it may be difficult for it to rely on its own non-compliance to say we can't comply. But I'm just trying to work out how this would operate under international law, which you say we're all bound by.
No, that is not the step in our argument. Our argument is you're not bound by international law. Our argument is that the status of the Mauritian peoples and the Chagosians' rights as a matter of international law is something that must be taken into account in the decision-making process. You, the Court of Appeal, the Divisional Court, nobody can direct the United Kingdom to comply with the ICJ's opinion. All you can do is to ensure that they take into account the interests of the Chagosians as identified in that opinion, and take steps which recognise the gravity of the interference with their rights. This is arising from the current status, that is, the failure to pass the territory back to Mauritius, and take into account in their decision making the impact and the extent to which that impact can be reduced of the interference with their rights. So there is the statement, or there is international law operating on the international plane, which on the international plane obliges the United Kingdom to take steps. This court can't do anything about that, but what anxious scrutiny requires is that this court takes account of that situation, and so does the Secretary of State, to try and consider, or certainly in its decision-making process, to consider how its decision-making is going to impact upon the enjoyment of those rights, both in form and substance. So, just briefly, to make good the relevance and the significance to this court of the opinion, Mr. Jaffe yesterday briefly referred to Sirda Mohammed, and that is in the supplementary bundle at tab 27.
Can you give us the, Ms. Kaufman, when you're referring, can you give us the volume number, because we have these divided in different volumes?
I am so sorry, I don't have the volumes because I have everything electronically. I don't know how many authorities there are in each volume. I'm really sorry. I could perhaps get somebody to quickly email me so that I can incorporate that.
Anyway, this is the supplementary bundle of authorities.
Supplementary bundle of authorities. It's tab 27, so I imagine that probably is in volume 2. And it's at page 1219. That's where the judgment starts. But at paragraph 23, we can see in the speech of Lord Sumption at E.
Oh, maybe you're going a bit fast. I've got. So we're in Kazin, is that right?
We are in supplementary bundle of authorities.
Yes.
So it's Sirda Mohammed, tab 27.
Yes, I've got that. Thank you.
It's page 1248.
Thank you.
Paragraph 23 of the judgment of Lord Sumption, and here he looks at E, if your lordships will read, he looks to the International Court of Justice. Its advisory opinion in the Namibia case, and relies upon it for its identification of customary international law. Now, the ICJ opinion deals not just with the right to self-determination as a matter of customary international law, but also the implications, the right of resettlement. And that is clear, as we saw from paragraph 181. And I just wanted to give your lordship some other instances of where that has been recognised. For your lordship's pen, I don't think we need to go there. In the core authorities, at tab 37, which I imagine therefore must be, are there two bundles of core authorities?
Yes, there are.
So in the second bundle, tab 37, there is the separate opinion of Judge Sebatunde. It starts at page 1727. That's the separate opinions, but her judgment starts at 1830. And paragraph 51 of her judgment, she deals with the right of resettlement. And it is also supported elsewhere by the General Assembly in its resolution 2229/22 in relation to Indian Spanish Sahara, the Western Sahara. That is in the supplementary hearing bundle at tab 57. This is again just for your Lordship's pen, I'll just give you the references. Page 1316 is the bottom right hand corner of that page, and over onto the next page you'll see this being dealt with. And that resolution was fully supported by the United Kingdom, and again in the supplementary bundle, tab 52, it's a supplementary hearing bundle, at page 503. And that's perhaps just worth turning up quickly. Page 503 of the supplementary hearing bundle in tab 52, bottom of the page. Supporting the UN efforts to reach a lasting and mutually acceptable political solution that allows for the self-determination of the people of Western Sahara. Supplementary authorities bundle. Tab 61, there is an article also from Scobie and Drew. Tab 61, I take it, would be the third bundle. And there on external page 3233, there is also a passage dealing with resettlement.
Can you give me that reference again, please?
Yes, sorry, that is tab 61 of the supplementary authorities bundle. And the tab before that, so tab 61, and the page reference is 3233. And the tab before that in the supplementary authorities bundle is the General Assembly resolution of 22nd of May 2019, to which Mr. Jaffe took you yesterday. And again, we can see resettlement as an essential part of the realisation of the right to self-determination. So the United Kingdom cannot comply other than by ceding, that is absolutely right, but resettlement is an essential part of that, and resettlement and enabling resettlement, or recognising the right of abode, are therefore matters which, albeit they don't realise the right, they mitigate to an extent the interference with the right, and they enable its realisation.
Mrs. Duff, can I ask you this question? Assume for the sake of argument that we ceded control back to Mauritius, and Mauritius then said that it didn't want anybody to inhabit those islands, perhaps for environmental reasons or for other reasons. Would those individuals have a right of abode which was parasitic upon the right of self-determination in those circumstances?
Well, as against their government, they would have to...
Mauritius.
As against Mauritius, that would have to depend upon the internal constitutional arrangements of Mauritius, and then that wouldn't be a matter for international law.
So they're in a better position by virtue of us not complying on your analysis than by us complying.
Well, they're certainly not in a better position. Our argument is that it is necessary to take account of those rights and to weigh them in the balance. It's not that you have to resettle them. It's really important to understand we are not submitting that there is a duty, a legal duty upon the United Kingdom to resettle these individuals that we can appeal to in this court in the United Kingdom and England. What there is a right, a fundamental human right, that falls to be taken into consideration and which entails that anxious scrutiny must be given to the decision-making process, and that is fundamentally different. Whether the government chooses to put them in a better place than they may be able, hypothetically, we have no idea what Mauritius might decide in the future, should it ever have control over its territory. But whether they decide to take a course that is more beneficial and could be enjoyed by the Mauritians, by the Mauritian peoples as against their own government, is a matter for them. The critical point for our purposes and for this court's purposes is they have to consider that right and its implications for their decision making.
But for our analysis, do we have to assume, in order to test the argument, and I know the politics might be utterly different, do we have to assume that the United Kingdom will abide by the council, the opinion, and in other words, C, and operate upon that hypothetical basis?
No, we don't have to assume that at all. The United Kingdom has already made its position quite clear. It's not going to. It's already entered into an agreement with the United States that they can stay there for another 20 years. There's no question that this court has to assume that at all. You can respond. I'm sorry?
Do we assume the contrary, namely that when they give anxious consideration to the opinion, that they take into account that they will not comply with it?
Yes. They are not going to comply with it. They are not going to concede. But that doesn't mean that they ignore it, and they're entitled to ignore it. If, as a matter of law, this court concludes customary international law confers that right upon the peoples of Mauritius, then this court is required to take into account that right in determining how the decision-making process by the respondent needed to take place. And in particular, that the right was a matter that fell to be considered by the decision-maker, irrespective of whether or not they were going to comply with it.
Right, and is the remedy you seek, therefore, no more than reconsideration?
Yes.
Is it actually, you don't prejudge what that reconsideration
Not at
might
all.
be?
Not at all, because that is a decision for the respondent. We are in conventional judicial review territory in the sense that this is a decision for the respondent to make. What anxious scrutiny does in respect of that decision-making process is it requires the decision-maker to take account of a fundamental right, to put it into the mix in its decision-making, to show that it has put it into the mix, to show that it has considered the factors in favour of the exercise of that right, or respecting it, or increasing the ability to enjoy it, as against those factors telling against. And it requires the court itself also to apply anxious scrutiny in ensuring that the decision maker has done that, and can show that the decision maker has done that. But ultimately, the decision is that of the decision maker. It is never that of the courts. And all the court can do, if it finds that there are flaws in the decision-making process because of the requirements of anxious scrutiny, and they're not being complied with, then all the court can do is say, go back to the drawing board and make this decision again. So can we look at anxious scrutiny and look at how, or rather not look at anxious scrutiny, but look at how the opinion and its identification of the right to self-determination as a matter of customary international law, how that feeds its way into the decision-making process. and we rely on the case of Smith. So we started with Bugdike yesterday, the first of those cases. Then there was Brind, and then there was Smith. Now, all these cases were cases that were decided before the Human Rights Act came into the force. So they were all about how decision-making was affected by rights which did not form part of domestic law. And in all these instances, they were rights which sounded on the international plane. And Smith was an example of it, because reliance there was placed upon the human rights enjoyed under the European Convention at a time before the Convention had found its way into domestic law through the Human Rights Act. So all that appeal could be had to was the rights that existed on the international plane as a matter of international law. So Smith is at Authority's core volume, and I hope this will be bundle 1. It's tab 11, and the relevant passage is on page 221. And I know the court will have looked at this many times, but it's worth going back to it. And I'd ask the court to read under the heading irrationality. So this is where anxious scrutiny applies. It's in relation to irrationality. And we see the test. So Mr. Panic submitted the court should adopt the following approach. The court may not interfere with the exercise of an administrative discretion on substantive grounds, save where the court is satisfied that the decision is unreasonable in the sense it is beyond the range of responses open to a reasonable decision maker. But in judging whether the decision maker has exceeded this margin of appreciation, the human rights context is important. The more substantial the interference with human rights, the more the court will require by way of justification before it is satisfied that the decision is reasonable in the sense outlined above. So there is a substantive element to that. You're going to have to actually engage in weighing, and you're going to have to actually give values to the competing interests. And the more important the right, the more will need to be the values that you put on the other side of the weights. And then if your lordships will just read yourselves all the way through to the top of page 223, ending with the Dilmaraja decision.
Yes.
And then I know that Sir James would want me to ensure that the court has also been taken to the passages between B and C on page 223. The greater the policy content of a decision and the more remote the subject matter of a decision from ordinary judicial experience, the more hesitant the court must necessarily be in holding a decision to be irrational. That is good law, and like most good law, common sense. Where decisions of a policy-laden, esoteric and security-based nature are an issue, even greater caution than normal must be shown in applying the test, but the test itself is sufficiently flexible to cover all situations. So when it comes to that weighing element and the need to show that there is the more important the right, the more the justification, then the court has to be very careful to stay within proper constitutional bounds when there are decisions that are very policy-laden and so forth. Now, that isn't our focus. We accept that this decision-making process, which engaged issues of cost, which engaged, in our submission, actually, not in any meaningful way, issues of security, because the Americans didn't, in fact, object to the outer islands being occupied, but social and economic policy as well, that the court has to stand back. It is certainly not in a position to second-guess the decision or the weighing of those factors. But what the court can do and should do is make sure the key and relevant factors are properly taken into account in light of the rights that are engaged and at stake. And in the submissions I'm going to make, I'm going to focus on how that didn't happen, bearing in mind, as I say, that this is a very policy-laden area of decision-making. So Smith makes it quite clear that where there is a right on the international plane, that is something which the courts can and should probably take into account, as should the decision maker, as bearing upon the decision. Now, the second route is...
Sorry, can I just ask you, Mr. Governor, can we take it that you accept, the appellants accept, pages 554, where you started at letter E, through to the top of 556, to ask us to, as laying down how we should apply the anxious scrutiny test? Can we take it from here?
Yes and no. So that's very important, but I'm going to take you to another case later. Only one more, and I'm going to take you to an article by Professor Paul Craig, and that will deal with anxious scrutiny and how you should approach it. So we won't have much more, but that is important.
Thank you.
So that's one route by which anxious scrutiny is required. The second route is that the right to self-determination is a part of the common law, and by that reason, and in precisely the same way as we addressed in relation to the right of abode, albeit the right is extinguished by the 2004 order, it nonetheless is one which bears upon the decision-making process for the very reason that the decision-making process is one which, depending upon the way it goes, can allow Chagosians some level of enjoyment of the substantive aspects of the right. And I can take your lordship very quickly to the route by which customary international law forms part of the common law. Jones, the Crown of Jones, is a very important case. That is a supplementary bundle of authorities, tab 15. But your lordships just need to note that because it's dealt with in a more recent case of the Freedom and Justice Party and the Secretary of State for Foreign and Commonwealth Affairs, which is at tab 30 of the same supplementary bundle, although tab 30, I fear, is in a different... tab 30 must, I would have thought, be second of the supplementary bundles. Starts at page 1585, but if your lordships go to paragraph 113, which is on page 1619. And if your lordships read 113 through to 115.
Yes.
So that's a second route by which the right as a matter of customary international law is something that has to be taken into consideration. So coming back then to what anxious scrutiny requires, and the one additional case I wanted to take your lordships to, it's WM, the Democratic Republic of Congo, which is a Court of Appeal decision. I'm afraid this is a late addition to the bundle. I hope your lordships have it. It's at tab 64, the last authority in the supplementary authorities bundle.
I don't seem to have that in my bundle.
I do apologise.
That's tab 64, is it?
We will make sure that we get a copy over to you.
Thank you.
What was the page number? Sorry, Miss Cowper.
It's the very last authority, and I'm afraid we're all having trouble with this. I must have an earlier version of my authorities bundles because I don't have it in my authorities bundle either, which I thought I'd copied it in. So I can't give page number. I'll see if
I see. Oh, no.
to me.
So I take it back. I didn't get a separate divider, but yes, it's page 3267. Is that right?
3267. It certainly had the page numbers added to it. So
This is WM.
It's WM Democratic Republic.
No, I do in fact have it.
My bundle, like yours, Miss Cowper, finishes at 3266. But don't worry, I'll look on the electronic law report. So
That's right, is it?
So
Yes.
do your lordships have it?
Yeah.
Dingemans and Lord Justice Green?
No, never mind. I'll pick it up later. If you just give me the reference and whatever you want, I'll note it. Look at it later.
So this is an asylum case. Place to start is paragraph 7, and the bottom of that paragraph, and just to be of assistance to my Lord Justice Green, I'll just read this part. It's an asylum case. Thirdly, and importantly, since asylum is in issue, the consideration of all the decision makers, the Secretary of State, the adjudicator, and the court must be informed by anxious scrutiny of the material that is axiomatic in decisions that, if made incorrectly, may lead to the applicant's exposure to persecution. This is an judgment of Lord Justice Buxton, and cites Bud Dekai as the authority for that proposition. But the important point to take from there is that the anxiety and the anxious scrutiny is something which is not just for the court, it is for all the decision makers. Secretary of State, adjudicator, and the court. This is an asylum case, so all those decision makers were involved. And then the court moves on at paragraph 8 to look at the task of the court, and moving from 8, 9 down to paragraph 10, still looking at the task of the court then says this. That, however, is by no means the end of the matter. Although the issue was not pursued in detail, the court in Packaway recognised that in any asylum case, anxious scrutiny must enter the equation. Whilst therefore the decision remains that of the Secretary of State and the test one of irrationality, a decision will be irrational if it is not taken on the basis of anxious scrutiny. Accordingly, a court, when reviewing a decision of the Secretary of State as to whether a fresh claim exists, must address the following matters. First, has the Secretary of State asked himself the correct question? So, one critical question in this case, one vital question is a fundamental right engaged that I have to take into consideration? The question is not whether the Secretary of State himself thinks that the new claim is a good one or should proceed, but whether there is a realistic prospect of an adjudicator applying the rule of anxious scrutiny, thinking that the applicant will be exposed to a real risk of persecution on return. The Secretary of State, of course, can, and no doubt logically should, treat his own view of the merits as the starting point for that inquiry, but it is only a starting point in the consideration of a question that is distinctly different from the exercise of the Secretary of State making up his own mind. This is all focusing on the right question. Second, in addressing that question, both in respect of the evaluation of the facts and in respect of the legal conclusions to be drawn from those facts, has the Secretary of State satisfied the requirement of anxious scrutiny? That's really important. Both in respect of the evaluation of the facts, anxious scrutiny is required, and in respect of the legal conclusions to be drawn from those facts, has the Secretary of State satisfied the requirement of anxious scrutiny? If the court cannot be satisfied that the answer on both questions is in the affirmative, it will have to grant an application for review of the Secretary of State's decision. And that is, in my submission, a very, very clear explanation of what anxious scrutiny requires, both in terms of who it applies to, who must apply that, and secondly, how it falls to be applied. Then I mentioned an article by Professor Paul Craig, and in my submission, this is many parts of this article are worth reading in its own time. He seeks very carefully to identify what, as had come to be seen by many, this hackneyed phrase actually entails, that it is a proper legal test and is not simply a phrase bandied about by the court whenever they want themselves to engage in a slightly more intensive review of a decision. For current purposes, it's in tab 62 of the Supplementary Authorities bundle, and it starts at page 3234. I really only want to take us through to the conclusion at 3251. If your lordships could just quickly read through to that conclusion. And you'll see that at the bottom of the postscript he sets out the basis for which he disagrees with Lord Sumption's speech at an Alba annual conference where effectively Lord Sumption rubbished anxious scrutiny on the basis it really does nothing other than what is already there in the Wednesbury irrationality test. And he distinguishes it for the reason that he identified in the earlier concluding passages, where he equates anxious scrutiny with the hard look test deployed in the US. And we can see again there is this concern with anxious scrutiny to look at process and to focus on process and to be demanding of the process undertaken so that the court can be properly satisfied that the process is one in which the rights have been properly engaged with, taken into account, weighed and considered by the decision maker, and evidence has been properly analysed and understood and facts equally properly analysed and understood. So, before we move on to the failures that we see...
Can I just make this point? In many other jurisdictions, particularly family and civil, we're now very, very familiar with the concept that proof or the court's satisfaction must depend upon the gravity of the issue. So in family cases, for example, if you're deciding whether or not to discontinue life-saving treatment, you need a particular standard of proof and of the court's satisfaction. And that concept of the more important the issue, the more demanding the court's appraisal and of the standard of proof to be achieved is quite commonplace. Now, you quite often find where there are different jurisdictions that particular phrases are adopted, but actually they are quite a common meaning. And so what I want to put to you is, although this expression anxious scrutiny is one which is particularly appropriate in the public law field, does it really amount to anything more than that the more serious the issue, the more serious the consequences of the decision-maker's decision, then the more seriously must the decision-maker be satisfied, and the more seriously and closely must the court pay attention to whether the right processes have gone through. Is it really any more than that, which is a common feature across many jurisdictions?
Yes, it is a process feature. It is about process both on the part of the decision maker and on the part of the court in reviewing the decision maker's analysis. But it has particular features. I'm not saying those features distinguish it from cases where there are other very, very grave impacts of decisions, because this is really about what one expects of people who behave rationally. They are obviously, as rational beings, going to ensure that the more grave their decision making, the more carefully they approach it, and the more carefully they reason their way through it. But what it does require is that that is shown to the satisfaction of the court in the decision-making process itself, and that the court will be very astute to ensure that the decision-maker is being held up to those standards. So that even if you are in a field where there is a great deal of policy choice for the decision-maker, such that you could never begin to say a decision was irrational on substantive grounds, that is, that it's perverse substantively, nonetheless, applying anxious scrutiny, the court may well find itself entitled to say the decision maker has got it right because they simply failed to recognise, or they took into account an erroneous factual basis, which, holding them to the standards of exactitude which anxious scrutiny requires, they cannot be forgiven for having taken into account. So it is about process, and it is about in implying into the decision-making process very, very high standards of accountability. So that's yes, and I'm not saying therefore it is different, and that's probably why the phrase has been used and picked up in all sorts of other areas, because it really is descriptive of what a rational decision maker should be doing, where decisions vary according to their gravity. Can I just touch, before I go on to the actual decisions themselves, on the settlement agreement, which is something that I think Lord Justice Green brought up yesterday, that was reached in 1982, and just deal with it very briefly. The agreement itself is something that we see in the supplementary authorities bundle in the judgment of Mr. Justice Ouseley. That is volume 12 of the supplementary authorities, so it should be the first bundle. This is a very long judgment. The agreement itself is at page 576. And this is then dealt with and addressed when, having had Mr. Justice Ousley's judgment against them, the Chagosians sought permission to appeal, and in the next authority, tab 13, at page 624, the relevant passages, your lordships read paragraph 10. You can see that there were some renunciation agreements that were signed. 10 through to 12. And then 14 through to 16. 14, they address the bank number challenge to the immigration ordinance and the Divisional Court's finding that that was ultra vires. So we could see that it wasn't raised in Bank number 1, and the Court of Appeal expressed its agreement with that and its understanding that it wouldn't apply to public law proceedings, and that's been the position of the courts and the government ever since. So there was reference in Bank number 2 for your lordship's pen, tab 16 of the core authorities bundle at paragraphs 13 and 21 in the judgments of Lord Hoffman in the House of Lords, starting at page 435, tab 13, paragraph 13, and 436, paragraph 21. Bank number 3 we don't have in the authorities, but we've looked at it, and there wasn't any reference in that case to the settlement agreement. Again, there was reference in Bank number 4, that's also in the core authorities tab 20, and at page 735, paragraph 10, and again at paragraphs 91 and 92, there is reference to the settlement agreement. And in these proceedings, the respondent has also referred to, as way of background information, the settlement agreement. So we can see that in the core bundle at page 828, paragraph 13.6 of their first instance skeleton. It's just one of the points they make by way of background.
Ms. Kaufman, we usually take a 10-minute break. Can you just let me know when is a convenient moment?
Shall I just give you the references and then we can do that then? So there's just two more references. And then
So what was the core bundle reference to the first instance skeleton?
that is page 828,
Yes.
paragraphs 13.6.
Yes, I got that.
And then also, in their detailed grounds of resistance, the respondents, that's at core bundle, page 683. Again, it's covered as part of the background. And in their appeal skeleton, the respondent at 13.2, which is core bundle 104 to 105. There is again reference, settlement payment was in full and final settlement of any claims by those who were displaced. This is a matter to be noted in the context of the support package decision. So it is something which has certainly been a matter that has implications for any future claims for compensation, but not for any claims in relation to public law decisions.
Just before we depart, I think there was a reference
Right, I think we can begin again.
So I want now to turn to the decision, two decisions that we seek to challenge. The first is the failure to consider at all whether to restore the right of abode as a matter requiring separate consideration to the question of resettlement. That is, whether or not to restore it irrespective of the decision not to resettle. And secondly, of the decision not to resettle itself. So those are two decisions that we challenge, and we challenge on the basis that anxious scrutiny was not applied. Now, the starting point for both those decisions is that, like the Divisional Court, the Secretary of State, the NSC, mistakenly started from the wrong premise, namely that the right of abode, having been extinguished by the 2004 order, had no part to play in its decision-making process. So there was the most basic failure to take account of a relevant consideration, namely the right of abode itself, or the right to self-determination as a matter of customary international law. And that obviously has major implications for the legality of the decisions, because, as we've seen, a decision maker has to engage with the right. It has to be form part of that which is taken into account and considered and weighed with all the other factors that favour respecting that right, and balanced against all the other factors that disfavour it in the decision-making process. So that is a fundamental flaw that undermines both decisions.
Ms. Kaufman, sorry to interrupt, but just going back to the settlement point, because I think it does engage at least the first criticism, the right of abode. One of the points of Banku number 2 was the right of abode plainly existed in the past. There was a terrible wrong done when it was ignored. That has been settled. So said Lord Hoffman. And then the European Court of Human Rights refused to admit the further complaints, part referring to the settlement. So if you're saying there's a failure to take into account the right of abode, I do think you need to confront the effect of the settlement on that historic right.
Well, in my submission, the settlement did not have an implication for the right of abode and its existence, and that wasn't what the judgment of Lord Hoffman concluded. His analysis was that there was a right of abode before the buyout order in 2004 was implemented, and we saw that in the passages to which I took your lordships yesterday, and his reference to the authority of Sims and O'Brien, because his view was that the 2004 order, by its express terms, removed that right of abode that he recognised pre-existed as a matter of common law, and that the settlement agreement simply had implications for the right to claim compensation in respect of what had happened by way of the removal of the Chagosians and anything thereafter, but it didn't bear upon the existence or non-existence of the right of abode. So in my submission, for the reasons I've already taken your lordships through, I wouldn't accept that the right of the settlement agreement has any implications on the right of abode, which is a matter of constitutional right and constitutional principle, and is something that exists in the realm of public law, not private law, which is what the settlement proceedings were concerned with.
But I know you're not dealing with A1P1, but in one sense A1P1 is comparable. The right to property is a very important fundamental human right, yet it may be expropriated with compensation. So in some circumstances, the fundamental right can be compromised by the payment of compensation. Now, when we're dealing with the common law fundamental right, there is at least, well, the question is there some sort of an analogy? There is a right, it has been thwarted, but compensation has been paid. So you say they're separate, but certainly from A1P1, they are they're interconnected under A1P1. I wonder if that's analogous.
Well, I'd submit it's not analogous to the nature of the right of abode as a constitutional right. That the settlement proceedings in no sense provided compensation for the violation of that right, and that is the basis upon which it was possible for proceedings to be brought challenging the 1971 orders, which were concerned with the extinguishment of that right, the 2004 order, which in its terms extinguished the right, and it was the very extinguishment of that right which formed the basis of the challenge. So it seems to me impossible, consistently with the House of Lords and then the Supreme Court having given judgment in those proceedings, which concerned at their heart the fundamental right of abode, for it to be said that the 1982 settlement in any way can be taken to have prevented any litigation in respect of those rights. Those claims simply could not have been brought and would not have been entertained by the court. And that's never been the case, and it equally cannot be the case now. So, moving then to look at specifically the failure to consider whether to restore the right of abode as a matter requiring separate consideration from the decision not to resettle. Now, the respondents' case on this, and the Divisional Court agreed, was that they were perfectly entitled to look at the question of restoring the right of abode entirely as a consequence of its decision to resettle. That is, if no resettlement was going to take place, then there was going to be no question of revisiting the right of abode. And in so doing, both the court and the Secretary of State were making the practical ability to exercise the right the decisive precondition for its recognition. Now, while there is undoubtedly, unquestionably, more value in a right where it is capable of exercise, it is not, or the flip side is not true, that there is no value in a right where it is incapable of exercise. It was recognised by Lord Justice Sedley that there is enormous symbolic value in the recognition of the right. And we saw before how Lord Carswell put it. It is, I'm going to actually just go back, if I can, to read exactly how he described this. Paragraph 123 in tab 16, page of the core volume, page 465, the desire to be able to remain in one's homeland is so deeply ingrained in the human psyche that the right not to be exiled could readily be regarded as fundamental given its high importance, and so forth. So this is a right which goes right to the centre of our sense of identity and our sense of being human, and its recognition is something which carries a value, a symbolic value that for being symbolic is nonetheless real and of weight and of moment. And it's important when we think about our civil rights, our civil and political rights, and how strongly they are valued as rights in and of themselves, irrespective of whether they are exercisable or not, because for many, because of the circumstances that exist and obtain for them, they are wholly unrealisable. They are rights in theory, but not rights in which they are able in practice to exercise. So it is in our submission fundamentally wrong to denude the right, to empty it of all content by virtue simply of the inability to exercise it practically. And that is exactly what the Divisional Court and the defendant did, the respondent did. But once you bring that right into centre stage, and they did that because they said the right has absolutely no role to play in this decision-making process at all, and I've already addressed why that is wrong and why it was engaged. So once you bring that right back in and have to engage with it in your decision-making process, then you have to balance the question of restoring that right, albeit it can't be realised because there will be no resettlement, against the costs of doing so. And of course, the respondent never engaged in that exercise at all. So it's important to ask, well, what would that exercise have looked like? Because we're asking, one of the questions we're required to ask is, what difference would this have made had anxious scrutiny been applied? Well, there are clearly some matters that would have had to have been taken into account on the positive side of the balance, and that is the inherent value of the right, even if not exercisable. What is its value? What is the weight that falls to be accorded to it? Secondly, very important in the decision-making, as we'll see later when I go through some of the facts, was the desire to do something right, something for the people of the Chagos Islands. That did inform the decision-making process going forward. That was a matter that, certainly for the Prime Minister's part, he was concerned with throughout the decision-making process. And tied to that, the desire to remedy a wrong, whether obliged to do so or not, that was something that played part of the Prime Minister's thinking. And the value of a formal recognition. Now, in the Divisional Court, when dealing with this issue, Sir James Eadie made reference to the costs. So he didn't pay any attention at all to the value and the benefits, but only to the costs. And one of the things he said, or what he did say, was that even if you restore the right of abode without providing for resettlement, this would result in costs being incurred on the part of the government. And he took his cue here from something that Lord Hoffman had said in Banku number 2 at paragraph 55. And it arises on the basis that some Chagosians might decide as a form of protest to come back onto the islands, to resettle, to live on a subsistence level, and that would then engage the responsibility of the state under Article 73 to make provision for the islands. And that's clear from paragraph 55 of Lord Hoffman's judgment in Core Authorities, tab 16. At page 445, and the relevant passage starts at B. And he says, funding is the subtext for what this case is about, and then at B, the attempt to achieve that through domestic litigation founded before Mr. Justice Ousley. That doesn't mean that the Secretary of State is bound to assume that these expensive proceedings are purely academic. He's surely entitled to take account that once a vanguard of Chagosians establishes itself on the islands, in poor and barren conditions of life, there may be a claim that the United Kingdom is subject to a sacred thrust under Article 73 of the UN Charter to ensure the economic, social and educational advancement of the residents and to send reports to the Secretary General. And as I say, in the Divisional Court, Sir James picked up on this and said that's one of the costs that might be incurred. Well, our answer to that is, firstly, it was simply speculation on the part of Lord Hoffman back in 2008. We know that no one had actually sought to enter the island in that 4-year period between 2000 and 2004, when there was no bar on resettlement. We're now in a situation 20 years on from that 2002 to 2004 period, where the Chagosians who grew up on the island and were born on the island are themselves many, many years older, and therefore the likelihood of taking any such course is going to be much less, much reduced. But the critical point here is that the NFC didn't consider this at all. It doesn't matter what Sir James says might have been the costs when he gets up and argues the point in the Divisional Court, or no doubt does again before your lordships. The point is, this issue was never ever considered by the NFC in the first place. They didn't concern themselves with the question. Now, had they done, they would have had to do so in a conscientious way, and they would have all had to ask themselves, what is the likelihood of any such resettlement? And just for completeness, I should take your lordships to what Lord Mance said about this in Mankey number 2, if we stay in that judgment, and move on to page 485. So this is back then. We've had Lord Hoffman's speculation, and then Lord Mance said, paragraph 170 to 171, a third factor now mentioned in conjunction with lack of feasibility and defence considerations is the imminence of the intention to repopulate. And then if you look, it talks about where it's not mentioned anywhere, there's a brief allusion, and then just below G, there is a brief allusion by Mr. Rammell in his reply to the question why the order has been made secretly, that there was always going to be an opportunity for these issues to be debated, but it was right, given the imminence of the intention to repopulate, that we considered action. And I believe we did so. And then at 171, he goes to look at the factual basis for those statements. The factual basis for these latter statements consists in press reports involving a group called La Lutte, in Creole for La Lutte, La Lutte, with diverse mixed support and aims, some of which are shared by some of the Lutte supporters, involved action directed at protesting against the ending of the US involvement in Diego Garcia, including some openly publicised, very general ideas about sailing a large peace boat to the Chagos Islands from Mumbai. Mr. Banker was reported in the Mauritius as attending one such meeting in April 2004, but as expressing opposition to any steps to close the base of Diego Garcia. And if your lordships just carry on reading through to the end of that paragraph, that was then. The position then was there really wasn't actually on the evidence anything like a concerted attempt to repopulate the island. And that was then, but if the matter were to have been considered now as it should have been, then the question would have been, what are the costs going to be now? How likely is it now that there will be any such attempt? And will it be possible to argue in the face of that there is any risk under Article 73, or is it likely that all that is going to happen is, or the most that is going to happen, is that individuals will be able to return there without needing permission, as of right, to visit graves, to spend a short amount of time on their homeland. But as I say, those are issues that would have to be answered by considering the matters in the here and now, which was never done. But even if it was likely, even if the conclusion were reached that some expenditure would be required, then the exercise would have to have been gone through as to asking how much that expenditure would realistically be in light of what is predicted to be the likely presence of people on the island. Would it be less than resettlement? And whether on balance, would that expenditure be something that outweighed the value in actually recognising the right? And none of that happened. And in our submission, that is unlawful, and the reason it didn't happen is because there was a failure to appreciate in the first place the significance of the right. I will just mention one point, which has a bearing perhaps on the degree of anxious scrutiny that one should apply in this situation. directly applicable, but since the decision of Banku number 2, there's been a very important judgment of the Supreme Court, which has a bearing upon how prerogative exercises of power, such as the implementation of the 2004 order, fall to be reviewed by the court when they are challenged, and that's the decision of Miller number 2. That is at tab 33 of the supplementary authorities bundle. And if you were to look at, turn to paragraph 1, page 1701. And to paragraphs 49 to 50. So it's no longer the case that one would review an instrument such as the 2004 order where it has the effect of abrogating fundamental rights. You would no longer review it on a Wednesbury basis, albeit with anxious scrutiny. You would actually have to find that there is reasonable justification for the measure in question. Much, much more exacting standard of justification and standard of review by the court. Now, we are not dealing with an instrument and its legality, but we are dealing with the question of whether or not to take steps to lift that instrument or remove that instrument. And in my submission, that is something that has a bearing upon the degree of scrutiny this court should give to the decision-making process. And it simply adds force to our already existing submissions on why the failure to consider the right of abode and its restoration, irrespective of the decision on resettlement, was an unlawful decision. Can I just, before moving on from here, make reference to an alternative route as to the necessity to consider this, and this flows from the decision of the Supreme Court in Banku number 4. Got this in our skeleton of paragraph 9, 6 and forwards of paragraphs 10 and 11. But I could just take you quickly to two passages in the judgment of the Supreme Court in the Core Authorities volume at Banku number 4, which is tab 20. And to paragraph 72, page 757.
Sorry, going too fast. Which paragraph?
Sorry, paragraph 72, page 757 in tab 20 of the core volume.
Core bundle of authorities.
Authorities, Banku number 4. going to quash or revisit the judgment in Bank Number 2 on the basis of material found indicating that there had been non-disclosure, and it was on the basis that the whole matter was being revisited, which resulted in the decision now under challenge. And we can see that Lord Mance refers to the decisive reason for not setting aside. And we'll see at the bottom. 3 lines up at the bottom of that page 757. In practical terms, the background has shifted because of the KPMG report, which we're going to come to in a minute, and logically the constitutional ban needs to be revisited. So Lord Mance sees this as a matter of logic. And then, if your lordships turn on to the speech of Lord Clarke, at paragraph 78, which is on page 759, see that he agrees. And that is the logic in our submission. You decide to revisit the resettlement, which was the basis upon which the Supreme Court determined that the order was lawful. The feasibility of resettlement, and if you decide to revisit that, you revisit all the issues, not just the question of resettlement, but you revisit the question of right of abode in light of the circumstances that now obtain. Because the ground has changed in many, many, many ways, which alters the weight to be accorded to different considerations, and alters, as we've seen, the considerations that are in play. As the Court of Appeal required us to do, we have to consider what difference it would have made had anxious scrutiny been applied to the decision-making process by the respondent and by the Divisional Court itself. Our first submission, our primary submission, is that with this court's task, and our task, is not to show that it would have made a difference to the substantive outcome, that is, that had the decision maker applied anxious scrutiny, the respondent, they would have reached a decision to restore the right of abode, irrespective of the decision on resettlement. That is not as far as we need to go. The very nature of anxious scrutiny is that this court should quash a decision where it finds that anxious scrutiny has not been given to the decision-making process, because that is what proper respect for the weight of the right that is at stake in the decision necessarily entails. And in this case, where no anxious scrutiny whatsoever has been given because the right wasn't recognised, and where no exercise has been carried out whatsoever, the only recourse this court can have is to require the decision maker to engage with the exercise in a lawful way. So we don't go so far as to say inevitably the decision maker would restore the right of abode. We couldn't possibly say that, but we do say that the failure to apply anxious scrutiny means that they must undertake this decision making process again. Can I move on to the resettlement decision? And I'm going to have to take your lordships to a little bit of the factual background in order to make good our points. And I want to start with recalling why the new feasibility study was commissioned in the first place, way back in 2013, and this was at the behest of the then Prime Minister David Cameron and William Hague, the then Foreign Secretary, to see what could be done to meet the aspirations of the Chagosian people. And we can see this from the witness statement of Peter Hayes. This is in the supplementary bundle, and it's right at the tail end of that bundle at tab 88.
Sorry, I'm so sorry, I missed that. Which bundle?
It's the supplementary hearing bundle at tab 88, and it's at page 677 of the hearing bundle. So the supplementary hearing bundle. Dr. Peter Hayes, 677. He was the director for the Overseas Territories from October 2012, this is from paragraph 1, until mid-December 2016. And at that time, or at the same time, he was commissioner for Buyout and the British Antarctic Territory. And he gives, in this very, very lengthy witness statement, over 100 pages, a detailed account of the entire decision-making process. So it's quite useful to look at this as a useful place to find an overview. So paragraph 41 on page 692, he says, I welcome 5 lines down, 692, I welcome the opportunity to revisit the policy on resettlement when the Prime Minister and Foreign Secretary at the time, David Cameron and William Hague, agreed to do so. But regardless of my own personal views, I saw my duty as a public servant to do the best I could to, in the words of David Cameron, see what could be done to meet the aspirations of the Chagosian people. And that desire to meet their aspirations was reiterated by the Prime Minister in November 2014, and this is in paragraph 70 at page 701.
I'm afraid I've got a problem with my bundles here. I don't know that I've got this document. I have a core appeal bundle. I have a supplemental bundle.
Appeal bundle.
A supplemental appeal bundle.
That should be the one.
But that only goes up to tab 75.
So you don't have the complete set. I think there's another supplementary bundle.
I have 2 core bundle of authorities and 3 supplementary bundle of authorities.
I think there are two bundles comprising the supplementary appeal bundle.
Right, well I don't have the second of those.
I'm in the same position.
That is not a good position for your lordships to find yourself in. I apologise for that.
I've in fact got it electronically, and rather bizarrely, in the authorities, which were very kindly sent to me as well, I got that bit of the bundle. So perhaps I've got one of my lord's bundles.
Oh dear.
Anyway, it can be supplied later. We'll take the references now. But it has to be supplied in due course. So I thought that when Mr. Jaffe went through the bundles originally, I thought I had got everything he mentioned, but maybe I misheard him.
Well, I do apologise, and I will give you the references now.
Thank you.
What I wanted to highlight at paragraph 70, which is at page 701, is that the review begins and KPMG set about doing their feasibility study, and time moves on into November of 2014, and this is before the draft of the feasibility study had been received from KPMG. A note was written to the Prime Minister and the Deputy Prime Minister from the National Security Advisor, dated the 11th of November, where he set out, that is the National Security Advisor, a reminder of the conclusions of the small group meeting on the 5th of March of 2013. And this is how he put the conclusions. The Foreign Secretary should commission a feasibility study to review our policy over Buyout, looking at all options and costs and making clear we took our responsibility towards the Chagosians seriously, but without raising hopes of further substantive concessions. So that was the note of the meeting. And on that note, the Prime Minister made a handwritten annotation, and this happened on the 13th of November 2014, and he said this: my memory of the NSC is more positive. We decided historically to commission the study to see what could be done. So it was a positive desire to see what could be done that informed the entire process of looking into the feasibility of resettlement. So KPMG then reported, and what it looked at and why is set out in its executive summary, which is in that supplementary bundle that your Lordship, my Lord the Master of the Rolls, and Lord Justice Green do have. The first part, I hope, tab 16. Not tab 16. Sorry. Yes, it is in tab 16, but it's on page 104 of tab 16 that the executive summary begins.
Yes.
And if your Lordships can turn to page 122 in that executive summary, 122 of the bundle, and at the bottom, at heading 3.3, we see the overview of the resettlement options. And if your Lordships can look at the three options that were considered over the page at 123. Large-scale resettlement in the first instance, and note that involves using Diego Garcia. That second line, end of the line, the form of resettlement would require infrastructure development on Diego Garcia and the outer islands of the archipelago in order to provide adequate support services and so forth. Medium-scale resettlement, option 2. And then again, you can see that that involves Diego Garcia. And then we have option 3, small-scale resettlement, incremental growth over time, and also involves Diego Garcia. And then we get a paragraph pointing out there's no mutual exclusivity about these options. They could be seen as representing a progression. And the very last line there, in theory, an option could be developed which was based only on an outer island settlement. But this has been discounted on environmental and practical grounds, and Section 5 deals with that. Should your Lordships ever wish to do so, Section 5 sets out history of, or rather factors relating to the environmental and practical considerations. It certainly does not say it is impractical on environmental, or impractical or impossible because of the environmental considerations. What it shows is it would be more difficult than the options 1 through to 3. And so the KPMG study proceeded with the 3 options that seemed most practical and most environmentally straightforward. And then that report was first considered by ministers in March of 2015 on March the 10th, and we can see that in, for your Lordship's pen, the report of Mr. Hayes, the statement of Mr. Hayes, in paragraphs 128 to 144, but we also have the minutes which record the outcome of that meeting in tab 22. And they start at page 244. If your Lordships go around, there's a lot of redacted material here. On page 250, after the red redaction, the Prime Minister said that the National Security Council was not yet in a position to decide whether to pursue resettlement of the British Indian Ocean Territory, but it was a useful opportunity to exchange views. So they had the KPMG report, and that wasn't going to be the end of the matter. And at 253 at the top of the page, just after green, summing up, the Prime Minister said, no decision on this issue would be taken in this Parliament. Further work by officials was required on both resettlement and non-resettlement options. And the further work then included consultation with the Chagosian diaspora. And it was in the course of that consultation, in the second half of 2015, that the possibility of settling only the outer islands and ignoring entirely Diego Garcia came first to be considered. And the reason for that was because the Americans had made it clear that they did not want anything to be going on Diego Garcia, and they certainly weren't going to lend any of their facilities, which had been part of the assumptions made by KPMG when they looked at the options 1 to 3 as the most practical and most feasible. So the Americans said, no, we're not going to do that, that's not happening, we're not going to lend you anything, you're not going to use anything of ours, you're not going to use our airstrip. And so the question of outer island-only resettlement came to be looked at in 2015. And we can see that in, again, for your Lordship's pen, in Hayes, in his first statement.
Sorry, Ms. Campbell, just before you leave that bit of the bundle, there was at page 257, which I think is relevant to your first round, the record of a discussion that the Prime Minister had after the Security Council, where he said he wanted better costs of the 3 resettlement options, but he would also value properly costed and itemised non-resettlement options.
Exactly. I'm very grateful. So he wants to get better understanding, this is at 257, 3 bullet points, better understanding of views on resettlement of the Chagos Island community, better informed assessment of the cost at the second bullet point of the 3 resettlement options, and non-resettlement options in the third bullet point. So that costings of the resettlement options identified by KPMG translated into a different set of resettlement options as time went on, and we'll see that in what was finally presented. And the outer islands became a focus, outer island only resettlement focus, starting with the consultation, and that is in paragraph 173 of Hayes' first statement at tab 88 at page 735. And it was, we can also see, I think, from the chronology, yes, if we look at the chronology in the core hearing bundle, the core appeal bundle, at tab at page 725, sorry, at page 163. See on the 29th of September, at the very bottom of page 1363, there's an email from Alex Cameron recommending that NSC paper should recommend just one option, an outer island option. So we begin to see a focus on the outer island only option.
So that's page 163.
That's page 163 of the core appeal bundle, and it's the entry in the chronology dated the 29th of September 2015. And it was following that, the reference to the outer island only option in the consultation, and that recommendation of Alex Cameron, that the Whitebridge report was commissioned. And there is reference to this, again for your Lordship's pen, in Mr. Hayes' statement of paragraph 187, 195 and 196. But the report, the Whitebridge report, your Lordships should have in the supplementary appeal bundle at tab 31. And the purpose of this report was to look at the possibility of an economy being established in the outer islands, and specifically high-end tourism. High-end tourism such as that which we see in the Maldives, Easter Island, extraordinarily remote parts of the world which have become very expensive eco-tourist destinations, and of course much, much closer to home, the Seychelles themselves. And that was something which was being considered by the Whitebridge report. And the Whitebridge report looked, for example, if we look at part 5 on page 2994, when looking at tourism resorts development costs and timetables, your lordships can in your own time look at this in more detail, but there is some very interesting details here identified of how resorts manage to go about existing in these extraordinarily remote islands, and what those building the resorts resourcefully are able to do in terms of creating the infrastructure, bringing in water, bringing in fuel, and making them entirely self-sufficient communities. And that's addressed there at part 5. And then, at page 309, there is consideration given to how on earth you get people to these islands if you're going to introduce tourism. And this is where consideration is given to an airport and lifting people in by air into the islands. And you'll see at page 309, Whitebridge consider the distance of the islands from other nations and other places where airports already exist. So we've got Garn International Airport that they consider first, then they look at Mali in the Maldives, they look at the Seychelles, and they look and they conclude based on the foregoing, it is evident that the shortest and therefore most time-efficient routing is likely to be via the Maldives. The table right summarises some useful facts and figures of relevance with regard to the most likely routings through the Maldives. And you can see that they talk about the Maldives, what aircrafts are available there and which fly, the aircrafts that fly in. And so you've got large aircrafts, the A320 family of jet aircrafts, but you also have these Dash 8 aircrafts, which have much less number of seats, and you have seaplanes, and you can also see that there is a description of the aircrafts themselves at the bottom of the page, and you can see what a Dash 8 aircraft is and how many it can take, 37 to 78 people, and then the DHC-6, which has a smaller capacity. And if you then move on to page 314, you can see consideration being given to possible building of runways in the outer islands. Map over leaf plot the approximate length. This is at the top of page 314 under the heading 9 lift solutions. A selected number of islands within Banos and Salomon Islands, such as island perhaps offering sufficient length and appropriate topography for a landing strip that could be serviced by either long-range jets or shorter wall propeller aircraft. These aren't high-lying islands, they're low-lying islands. And so we are looking at the possibility by reference to their length, and we can see long enough to accommodate Dash 8 aircrafts. South Island could even work for an A320 jet, but there's concern about the costs of that. So West Island, insufficient for a A320, good enough for a Dash 8. So plainly, we've got islands that are long enough to accommodate aircrafts landing as part of any attempts to make tourism work in the outer islands. But when the matter came, or I should say there were no costings done of this, and there were no costings done on the basis of the Whitebridge report as to what it would cost to build an island. And in relation to that, for your lordship's pen, and this wasn't before the decision makers at all, but it's relevant because we say that had the matter been considered on, something like this should have been before the decision makers. The evidence of Richard Gifford, which was put in on behalf of the appellants, in his second witness statement, you don't have that now, it's in the supplementary bundle, but for your lordship's pen, after the hearing. That's tab 92. And on pages 821 forwards, paragraphs 27 to 41 deal with the costs of building an airport that these islands could accommodate, as opposed to an international airport meeting international airport standards. So no costing's done, but when the matter did come before the NSC, this is how things were presented to them. So if your lordships can turn to tab 40 in the supplemental bundle, minutes of the NSC meeting. If you turn to page 399. Under the green redactions, the permanent Undersecretary of State at the Foreign and Commonwealth Office said that between 1,500 and 2,000 Chagos Islanders have been removed, etc., etc. And if you then come to three lines above, the yellow redactions, with a line starting the first slide, set out the three main options. Option A was the resettlement involving the island of Diego Garcia, the location of the US airbase. The option was strongly opposed by the US government. Option B was resettlement on the outlying islands, excluding Diego Garcia. These islands were a 5-hour boat trip from the US airbase. The largest was the size of Hyde Park, which ruled out building a landing strip. And the highest point was only 6 feet above sea level. We see the low-lying. This would be an even more challenging location for resettlement than option A. Option C would involve a package of ODA, eligible development assistance, designed to improve the lives of Chagosians in Mauritius and the Seychelles, and an enhanced programme of heritage visits to the islands. These visits were valued by the Chagosian diaspora, who retained an attachment. So we see that it is said about option C, but it involves a fundamental factual error about the ability to build an airstrip. Rules it out in terms on the basis of the size of the islands, the largest the size of Hyde Park. Now, would that error have been picked up by those who were present? It's right to say there is nothing in the minutes or anywhere to suggest that that error was picked up or corrected by anyone. And this is a statement that is made to a busy group of ministers who have come together to look at this issue and make a decision. Would it have been picked up? And the answer to that is no, not unless they read incredibly carefully through the KPMG report itself. So on the materials that were provided...
Now, sorry, just so we're absolutely clear, precisely what error? How would you define the error?
It's an error of fact.
What is it precisely? What is it that is picked up?
That it is the building of an airstrip is ruled out on the grounds of the size of the areas on the outer islands, the largest being the size of Hyde Park. The sentence being, which is an erroneous statement of fact, the largest of the outer islands was the size of Hyde Park, which ruled out building a landing strip. So none of the matters that were accompanying this, other than somewhere in the detail of the KPMG executive summary, would it have been identified that that was an erroneous statement of fact? So there are slides that accompanied this on page 419.
Sorry, just to press you. Is the error that the largest was in size of Hyde Park, or that there was practical space on some island or another for an airstrip?
The error is that the size of the island rules out building a landing strip. That is the error.
Size of the largest island?
Yes. The site of the largest island rules out building a landing strip. Because it necessarily follows, the implication from that is you certainly can't do it on the smaller ones if you can't do it on the largest one.
Yeah. Okay. Yeah, thank you.
So, yes, for your Lordship's pen, there is a mention of Hyde Park in one of the slides, but it doesn't say anything about the possibility of building an airstrip. It doesn't indicate that despite the fact that it's the size of Hyde Park, you could build a landing strip. So it does nothing to remedy that error, and there would have been nothing in any of the other slides that would have enabled anyone to understand, who doesn't understand and have technical knowledge about the requirements of building an airstrip, that you could have built an airstrip, even though it was the size of Hyde Park. So there was no correction of that fundamental error.
Was this point raised before the Divisional Court?
Yes, it was.
I'll
bring your Lordships onto what the Divisional Court said about this.
Thank you.
Because they said it wasn't an error. Well, I'll bring you onto it, and I will set out my submissions as to why they were wrong in their analysis, both of what was said, but also the legal implications.
But just so, because you're taking us through quite a lot of stuff, so I'm just trying to make sure I processed it all. You said it was the Whitebridge report which said that it would be possible to land aircraft there. You've then taken us here to say, well, this is an error here in relation to this meeting of the Security Council. But then you also mentioned about KPMG's report.
So the reason I mentioned KPMG's report is that when the NSC met, they had materials before them which form part of the briefing package for them to be able to make the decision. And the KPMG executive summary was there before them.
And I'm just trying to remember, I'm sorry, because we came back to it. The executive summary does refer to the possibility of an aircraft, of an airstrip.
Of an airport on the outer islands.
Yes, thank you.
Hidden deep in the depths of its pages. That is something that somebody who had read the whole KPMG report would have seen. And one has to ask oneself, would a minister, a busy minister, have read all of the KPMG report, or would the minister be reliant upon the briefing materials and the advice provided by civil servant officials? And that has a bearing when one looks with anxious scrutiny at the decision-making process.
Thank you.
And what needs to be told, and the accuracy of the facts that, and the fullness of the facts that they need to take into account. So we set out in our skeleton argument key case law on mistake of fact or failure to take into account relevant considerations. I don't need to take your Lordships to that. It is quite clear that on conventional Wednesbury grounds that the court can quash a decision where there is a material error of fact. That's clear from the Thameside case, Supplementary Authorities tab 5, page, that's 1030, and it's on page 1030 at E. And also the National Association of Health Stores and the Department of Health at Core Authorities tab 13, paragraph 60 forward. Failure to take account of relevant considerations of another basis for challenging. So where there is a consideration that must be taken into account because it is so obviously relevant to the decision-making process, then if it isn't taken into account, you can quash and should quash the decision. So here, this can be characterised as a mistake of fact or a failure to take account of a relevant consideration, that consideration being that you can build an airport. And in the context of anxious scrutiny, it was a significant and important error because it was recognised that the KPMG options were no longer realistic or viable in light of the position taken by the United States. So the desire of the Prime Minister to see what could be done for the Chagosians necessarily translated it to seeing what could be done in relation to the resettlement of the outer islands. That was going to be the only viable solution, if solution there was. And therefore, it was vital that in considering that outer island resettlement process, the ministers understood what the possibilities really were. What the possibilities were in respect of bringing in income onto those islands, because they went to the costs that would be left to the United Kingdom to bear, insofar as costs couldn't be generated through a private income, through ecotourism, which was the only viable solution being put forward. So the fact that ecotourism could get off the ground by the building of an airport was a fundamentally important consideration for the decision makers to take into account and to weigh in the balance. Because, of course, it went towards resettlement, it went towards the Chagosians being able to exercise their rights, and it was a fundamental consideration to be taken into account in beginning to assess and analyse the costs, which hadn't been done by the time the decision was taken. But the decision makers were told something about the costs. They were given information about the costs, and that was information about infrastructural costs that would have to be incurred, but which didn't take into account the reduced costs if an airport were built of the kind that had been identified by the White Bridge report. Just bear with me a second. I want to see where it is that they were told about the costs of the various options. I can take your lordships to that. And maybe I'll just have to come back to that after the lunch adjournment quickly to give you that. But those were two. So that error of fact had critical implications. Firstly, in terms of feasibility. Secondly, in terms of costs. Costs to be incurred by the government if that option went ahead. And in our submission, where anxious scrutiny is required, it was vital that the decision maker properly considered and showed itself to consider on a proper factual basis the true viability of the resettlement option on the outer islands and the costs implications of that on a properly ascertained basis, that is, on a proper factual basis. And that didn't happen. What did the Divisional Court make of it? So, first of all, what the Divisional Court did was it went through, and this is, if we can turn to the judgment of the Divisional Court in the Court Appeal Bundle, and the judgment of the Divisional Court is at 21, and...
Well, I'm just wondering whether we should, it's now 1 minute to 1. Would it be convenient to, if this is a new section of your submissions, would it be convenient to deal with this after lunch?
I'm very happy to do so, yes.
And now how, because
I really shouldn't be too much longer. I'm sorry that I've run into the afternoon, but I'm hoping that I will be perhaps 10 to 15 minutes.
Very well, thank you very much. 2 o'clock.